Welcome. In this conversation, we'll be talking about professional regulation, particularly in the healthcare industry. We'll talk about three topics. The first will be the social perspective of regulation. The second will be kind of the legal and administrative structure of how regulation occurs. And then we'll talk about how regulatory enforcement action occurs. Let's first look at the social perspective of professional regulation. Um, Certainly the most argued or majority position is that we need professional regulation because it assures quality. People have it can assure that folks have a certain minimal skills entering the profession, that they practice their profession in a safe way, and so on. There is the counter argument, particularly if you have been reading Illich, that in fact it is a protection of the guild, that the reason that we require licensure of doctors is because we don't want anybody else practicing in that profession. We want to be able to hold up the prices, and we want to make sure that we protect ourselves. The other argument is that because of professional regulation, innovation is limited. It keeps out people who have new ideas. It limits the ability of other folks to have input. I welcome your thoughts on that. Let's look now at the administrative structure within a state government, whether that's Virginia or Ohio or California, and see how that's organized. For almost all of the individuals who are licensed, it will fall under a general department, usually referred to something cleverly like the Department of Health Professions. Within that, there will be subdivisions such as the Board of Nursing, the Board of Medicine, Board of Optometry, that deal with each of the individual specialties. For institutions, they are usually covered by the Department of Health, and within that is a subdivision referred to as the Office of Licensure and Certification, that deals with the application of regulations. On top of that, of course, we have the federal government, who comes at regulation in a little bit of a roundabout way, in that if a provider participates in any federal funding program, then they also agree to the regulatory overlay that goes with that. For example, if you are a Medicare or Medicaid participant, you agree to the regulations of the federal government for participating in Medicare or Medicaid. That involves the whole investigatory structure, plan of corrections, and so forth, that if you have been involved in that side of healthcare, you're well familiar with. Let's turn then to how a government entity goes about enforcing regulatory actions. You read in the very first section the administrative code that is common to most states, in that it lays out the procedure for administrative actions, in our case against healthcare providers, of what the kind of due process is going forward. Most administrative actions are initiated by a complaint. However, it may be that there is a survey in an institution. They either are regularly scheduled or an instant survey, and that will prompt a action against the institution. That investigation is then undertaken. It may be with the licensee's knowledge, or it may be without the licensee's knowledge. They don't necessarily have to notify the physician or nurse or whoever else that an investigation is going on until they are ready to interview the licensee, if they want to. It's not necessary that they do. One of the interesting problems that we've encountered is that recently investigators, for example, in Virginia, have decided not to share records that they've collected with the target of the investigation, despite the fact that administrative code requires that they do. One of the ways of resolving an administrative action is with what is referred to as a confidential consent agreement. This is available for healthcare providers, and it is limited to fairly benign situations such as improper advertising, failure to update a physician profile, maybe late in paying a fee, that sort of thing that does not involve risk to patients. Usually, if in the investigative process the particular board determines that further action should be taken, then the next step is what's referred to as an informal conference. At that conference, usually 3 members of the board will sit and speak with the licensee. I often joke there's nothing informal about it for the licensee. It feels very rigid and very accusatorial at times, in that because it's an administrative conference, there is no rules of evidence. The board members can ask anything they want to, and there is no judge there to referee. The chairman of the committee entertains any objections that are made, but as you might guess, rarely are they sustained. And so it is a fairly freewheeling exercise. The goal in representing a licensee in these situations is to assure the committee members that the licensee is not a risk to the community or to patients, that whatever the issue is has been addressed and will not be recurring in the future if there was in fact any deviation from the standard of care to begin with. If a licensee is not satisfied with the outcome of an informal conference, or if the informal conference determines that they want to take an action for which they're not empowered to take, that usually means suspension of license or termination of license, then the next step is a formal conference. A formal conference is conducted just like a trial. The Attorney General will act as a prosecutor. There will be another Attorney General who will act as a legal advisor to the chairman of the board to deal with any rulings. I have questions sometimes as to whether or not there might not be a conflict of interest there. And the licensee can be represented by counsel. Witnesses are called, put under oath just as they would at a trial. Documents are admitted into evidence. But again, the strict rules of evidence are not enforced. For example, hearsay can be admitted. There does not have to be a strict foundation laid for the admission of documents. It is, for an experienced trial lawyer, can be often quite frustrating in that just stuff comes in, whether or not it has a strong evidentiary basis. It is not unusual to be able to win a medical malpractice trial, but have the same action come before a formal committee or an informal committee, and the licensee becomes sanctioned because of the nature of how evidence comes in and as to the perspectives that each of the board members bring about whether good medicine was practiced or not. The challenge of these conferences, particularly the informal conference, is that there is no requirement that the members of the panel actually be in the same specialty as the provider. Years ago, my picture was in the paper with one of the board members. I was showing a neurosurgeon where on a x-ray the staple line for a gastric bypass procedure was, because he did not know how to find that. He didn't practice gastric bypass surgery and had no understanding of how that surgery was conducted. The chairman of that informal conference was a podiatrist, and however, he proclaimed that he had great expertise because he had sold surgical equipment one summer as a student. And then the third was a citizen member who fell asleep at one point during the conference. Needless to say, it can be quite frustrating to a healthcare provider to be in that situation. And the goal, as always, is to assure that we have over-prepared for those situations. If one is not satisfied with the outcome of the formal conference, which is the end of the administrative side of the house, then the licensee or even the state could appeal to the circuit court for a review of the formal committee's findings and order. There is very limited recourse at the circuit court level. It has been broadened some. Historically, it was the only question was whether or not the agency had followed its own rules. Now, the circuit court can review in a limited fashion the substance of that opinion as to whether or not there was a reasonable basis for that opinion. It is not a de novo, i.e. a whole new review of the case to determine whether the judge would have reached a different opinion or not. It is simply whether or not the board had a reasonable basis for the action that they took. That is the end of our conversation about the professional regulatory process. One can often feel like a very small fish if you're on the target of the regulatory boards, who often by the licensee are perceived to be quite the sharks. But with that in mind, I leave you with Nemo here. Thanks for joining me.